Welcome to the Hip Talks podcast, a series of discussions about current legal issues hosted by Hugel & Nip Solicitors. We are a young, independent law firm, but with decades of experience providing bespoke legal advice and exceptional client service to individuals, families, entrepreneurs, and businesses, both in Hong Kong and internationally.
So I'm here with Alfred Ip to discuss some of the topics under the big umbrella of private client, estates, and trust. So, Alfred.
Hello, Margaret. How are you?
I'm good. How are you?
I'm very well. I'm very glad that we have the opportunity to talk about estate planning today.
Excellent, because I really wanted to ask you, why do I need to make a will? Why is it necessary for me to have a will?
Well, I'm sure that you have no plan to die, but you never know. The point is, with a will, it actually helps with anything that your family would have to deal with if something happened to you. First of all, I know that a lot of people do have a family. When they're setting up the family, first they thought about getting married, and then they thought about having children, and then they will start about setting up a home, buying a property, start paying for the mortgage, and then the children start growing up, and there will be a little bit of accumulation of wealth. Things all go very well until such day when something happened, and it's traumatic when something happened to the one that you love. And if that case, no estate planning is in place, the family, while grieving for their loss of you, they have to deal with the probate process in order to get the family wealth into their hand. And a lot of situation it's actually very traumatic when they're suddenly losing the financial dependency because everything is locked up. And the purpose of a will, a lot of time, is not only to make sure that the person that you want to benefit will inherit your wealth, but also to make sure that the probate process can be processed as quickly as possible. In Hong Kong, probate process is not particularly straightforward, and having a will would greatly benefit in terms of expediting the whole process.
Are there any important things that I should make sure I include in the will then?
Okay. First of all, of course, you have to make sure that someone will be inheriting your wealth, your hard-earning money. A lot of time, if you're married with children, you want to make sure that your spouse will get everything, but then because your spouse will be looking after the children for you. And a lot of people do have a misconception that when you're married with children, after something happened to you, your spouse would automatically inherit everything. That's actually not true, because under the intestacy rules in Hong Kong, your spouse would be first getting $500,000 from your estate, and then he or she will be entitled to half of it. The other half to be split among your children in equal shares. But that is actually not the major problem. The major problem is if the children are still small, who is going to look after their share of the wealth? And in that respect, the problem is that under the Hong Kong laws, it requires two administrators in order to look after the benefit of the children. And in that case, your spouse have to find another person to co-administer the estate for her, with her, or together. And the first person that he or she will have to go to is your other family members, such as your parents or your siblings. If they have a good relationship with them, it's all fine. They work together. If they don't, it would be quite embarrassing. And more so is that in order to prove the relationship between the spouse and you and the other family members, they have to produce a lot of public documents, which delay the whole process. Having a will in place will make sure that all these problems will not arise.
So it sounds like a will is a very powerful document and probably very necessary for a lot of people, especially have families. So given that it is such an important document, what kind of requirements or elements should I make sure that are definitely incorporated or are part of a good will?
Okay. First of all, I think the easiest way for you to make sure that it's properly done is to go to a lawyer. Because at the end of the day, I can be very honest with you that making a will is relatively easy. All you have to do is to write it on a piece of paper with 2 witnesses witnessing your signature to make sure that you are the person who signed it. But of course, with so many years of experience, we have seen a lot of homemade will which are not done properly and actually give more issues than solutions. And I remember a lot of cases actually is written on a deathbed. And they do not realize what's the problem with it when it's not written properly. I still remember one case that is the deceased said, I leave it to my husband to handle it as he wants. It sounds like he's inheriting the wealth. Perhaps it's her intention to let him inherit the wealth. Mm-hmm. But to write it as such, it's like, is he only administering it? Mm-hmm. Or he's entitling or inheriting it? It actually poses a lot of more issues than solutions. Mm-hmm. And this is only one of the many bad examples for homemade will. And that is why it's very important to have it properly drafted. All we have to say is that A or B will inherit my will, for example, inherit whatever that is I have, or in another way, of course, will not. Eventually will be drafted as such. Mm-hmm. The most important as well is to make sure that your witness, who witnessed the signature of your will, is not a beneficiary named in it. It's for the very simple reason that the law makes sure that you are not signing the will under any duress, and you're not forced by the witness. So, it may sound very logical, but a lot of people are not aware of it, and we've actually seen some of the cases when beneficiaries have disinherited because of that, and the family members have to spend millions of dollars on the litigation.
Okay, so we've touched on quite a few points here just now about elements that are important for a good and valid will. You mentioned something in your example earlier just now about the wife who signed on her deathbed her own will for her husband to handle everything. So is it important to have a good choice, I suppose, for someone to handle all your affairs or appoint someone to handle your affairs under the will?
Yes, and we usually call it executor. But then that person has to be someone that you can trust, because he or she will be acting as a trustee to look after your wealth for the benefit of the people, children or otherwise, that you want them to inherit. So it's actually very important that that person would not be abusing their power for their own benefits. And of course, under the law, they have the fiduciary duties to look after the interests of the beneficiaries. But then in real life, we always say, it's actually a burden for whoever who doesn't have the knowledge or experience to look after a big amount of wealth. And actually, I don't know if a lot of people would have this troubles of looking after a lot of money, but then I can assure you that if you do not know how the investment market turns, what are the tools for the financial products that can preserve the capital or create a stable growth, it's actually a lot of work. Mm-hmm. And in that particular respect, a trustee under the law, unless he or she is specifically empowered to make any investment decision, they are under the duties to preserve the wealth. And it is only prudent, as like a prudent businessman standard, to invest in the family wealth with something that is capital preservation, something along the lines of fixed deposit, or government bond, or any financial products which is predominantly capital preserved. But then, as you probably know, we are in a financial world that there are constant appreciation, and a lot of time with a very conservative investment strategy, the wealth cannot grow to serve the needs of the family. So sometimes, especially when we are talking about a very substantial amount of wealth, the trustee requires help. And professional help, we're talking about investment managers. It's better to have someone to help them in that respect. And in that respect, the law actually does give them power to do that, but it's, of course, more prudent to have a well-prepared will to make sure that the trustee are aware of the power to invest, to appoint investment manager to assist them in the daily administration of the wealth.
So you were talking about trustees just now. Is it mandatory then for your executor under your will to be a trustee, or is that just one of the options that you have?
Actually, it's kind of the role that they assume themselves into when they become appointed as executor, because they're performing the one function of holding the wealth for the benefit of the beneficiary until it's distributed in accordance with your will. So there's such a time that they will be holding the wealth. And that's why they're so important. If they run away with your wealth, your beneficiary would not be benefit from under the estate. And of course, that would be totally dishonest. But then a lot of time, actually, there are a lot of decisions that the administrator may make and that the beneficiaries may not be entirely happy with it. And that's why we emphasize the importance of having a professional, someone that knows what they are doing, and they will perform their role function properly. Under the law, under the intestacy rules or the probate administration ordinance in Hong Kong, family members were priority to administer the estate. But then, of course, most of them are not professionally equipped. So when we are dealing with a substantial amount of estate, it is only prudent to appoint a professional administrator to administer the estate properly. And that actually is the exact case that we did many years ago when the only reason for the court to pass over, we call, the person appointed under the will as the executor, who is the youngest son of the deceased, is because of the value of the estate. And we are talking about billions. Mm-hmm. When we talk about billions, the court is not entirely comfortable with someone who is not professionally equipped or experienced to administer the estate. So when we are talking about a substantial amount of estate, there should be extra caution.
Mm-hmm. So it looks like the executor, or as the role they become is as your trustee, they actually also have a lot of power when they are granted the title of executor of an estate. Absolutely. So is there any way I can limit their power? Like, yes, I'll trust this person, but I won't trust them with everything. So is there any way I can limit or restrict or grant certain powers or obligations on this person?
Yes, you can, but actually, there's actually something about communication. When you're entrusting someone to do something and then you want to limit their powers or confine them into doing something and not doing something, that requires a very good communication with clearly drafted document to make sure that the person understands what he can do or not he cannot do. It's either by way of a will with clear powers and duties and rights and remedies, or you can do it by way of letter of wishes if it's something that is more personal. The most important part is to have a check and balance. The beneficiaries are fully aware of the power of the administrator so that they can check whether that person is performing their role properly.
So this letter of wishes then, if obviously the will becomes in a very legally binding document once the probate has taken place, mm-hmm. But what about a letter of wishes? Is that also a legally binding document?
Actually, it's not a legally binding document. It's just that it is a way that you tell the administrator what you want him to do as your wishes, as the title suggests. And it is, in a way, the administrator has to give sufficient reason to justify any deviation from the wishes that you express. Because at the end of the day, you cannot tell him what to do and what not to do anymore because you're 6 feet under. Mm-hmm. But then it's very important at the same time for the administrator to answer to the beneficiaries if they decide not to adhere to the letter of wishes.
So if, given that I do have, in fact, a trustee under the will, how can I actually set up a trust if I really do want to set up a trust and so that they are, in fact, genuinely a trustee and not just an executor with a trustee's role?
Actually, by assuming the role as the executor, they or she becomes the trustee, mm-hmm. because that is their role
But then can I also create an actual trust in my will or
Yes.
through my will?
Yes, and that in that case, it would be a will trust. But then there are clearly benefit of disadvantage in terms of creating a will trust. Part of the reason is that a will may become a public document after it's been probated. And creating a will trust would necessarily disclose all the terms and conditions in the will trust that usually can be found in a trust deed. And the benefit of setting up a trust during your lifetime, we call it an inter-five-will trust, is that it's confidential. Nobody has right to access to the terms of the trust deed and the terms and conditions. And for a lot of people, it's actually a very good way to keep the family wealth confidential. So to answer your question, is, of course, you can do it by way of a will trust in order to retain control of all your wealth until the day you passed away. But then there is a clear disadvantage of the confidentiality. And another thing that we have to look into is actually there are more and more people who are getting a bit older that they may come to a stage that they cannot manage their own affairs. And we can talk about it later with the enduring power of attorney.
Okay, sure. I'll just continue on with the wills topic then. Let's move on to the beneficiaries. So for the beneficiaries, are there any limitations on who or maybe even what, say, for example, could charities be beneficiaries under your will as well?
Oh, yes. In Hong Kong, actually, there's a testamentary freedom. You can basically do whatever you want with your will to leave anything to anyone, including charities. The only thing is that if you leave it to the charities, and any of your financial dependents will be worse off, or they're losing the dependency because of that, they may challenge the provision to the in the will. And in that respect, in Hong Kong, actually, there's no forced heirship rules. You're not compelled to leave everything or anything to any of your immediate family members. But then, of course, if you decide not to do that, actually, it would be advisable to make sure that he or she will understand your decision and the reason for it. Because it is a lot of time that lack of management that give rise to testamentary disputes.
So it sounds like before you finally execute your will, you should really make sure that all the people who are referred to it, the executor/trustee, as well as all the beneficiaries, they are all clear about what the terms of your will in fact be.
Yes.
Lots of communication needed then.
Yes, and communication and the management of it is something that a lot of people are not aware of when they're advised about estate planning. It's really a point of how to deal with your things after you cannot manage it yourself.
That sounds very, very important because I like my things.
Oh, yes. If you have a few favorite things like Birkin bags or your Malolo, you do want to leave it to somebody. And that person should know how to cherish it. And leaving it to the intestacy rules may not cover your needs.
So that brings up a really important point then. For very small personal items such as my Birkin bags and my Manolos, those will be technically usually called chattels.
Yeah.
How can those also be bequeathed under a will then?
Oh, yes, absolutely. And all you have to do is to make sure that it's clearly defined, like your shoes, which color, which brand, or which handbags. And of course, if you have a collection, make sure that you're not referring to one, but a collection.
Understood. Okay, now here's another question about my assets then.
Okay.
What if I have assets in all the countries that I've visited or lived in? Houses here, a boat over there, cars and collections of random art in another place. How can I deal with all of these assets?
This is actually one of the questions that I'm most frequently asked. And actually with globalization, a lot of people do have assets in multiple jurisdictions in many different countries. And actually, a lot of time they are advised that they should make a will in every single country because it is only proper to administer it properly, to plan it properly. when they ask me the same question, I'll say very much depends. Depends on what you have in which countries. For example, if you have a flat in London, it will be very different from the way when you have a holiday home in Phuket. The treatment will be very different because the legal system in the UK and Hong Kong are very similar, but it's completely different in Thailand. And not to mention that in Thailand, everything's in Thai. If you make a Hong Kong will and you bring it down to Thailand to enforce it, it wouldn't help with the simplification of the succession process. And of course, if it is possible, perhaps it's advisable to use an asset holding vehicle like a Hong Kong or BVI company to hold the property in Thailand, because you transfer the shares of the company instead of the title of the property. That would actually save a lot of work, potentially tax as well.
So it sounds like there could potentially be benefits in having multiple wills if you have very, very different jurisdictions.
Correct. So at the end, it depends on what you have, where you have it, and it's professional advice that you should seek when you have different properties in different jurisdictions.
But would there be any concern about conflicts between your different wills?
Yes, absolutely, because it's very common for a will to have the first clause saying that I hereby revoke all my previous will or testaments to an instrument. So it's important when you have multiple wills to have them managed properly, to make sure that you will not forget that you have made a will in one country and then later on make another will to revoke it without making any provision, or it's not your intention. So the easiest way to do, go to a lawyer who can advise you properly and keep all the wills with the lawyer so that he knows that, oh, you've done this, you've done that, to keep you reminded. At the end of the day, you don't take out your will and review it every day.
That is very true. One more final question about how I want to deal with my assets. Going back to a more local scale and not so globally, what if I have one asset that I want to deal with specifically for maybe just one of my beneficiaries or a charity, say one of my numbered accounts, and then the rest of my stuff I just want to give to the grandchildren or the children? How can I deal with that?
The easiest way to deal with it, of course, is to make a provision in the will saying that I give this particular account to this person and the rest to a group of beneficiaries or class of beneficiaries in accordance with the share that you designate. So it's the easiest. But then we have come across a situation when it may not be entirely to test the interest or the intention of the one who make the will to put everyone in one single document.
Yes, I want to keep something secret. I don't want them to know about that numbered account.
Exactly. And that is the case that they want to preserve the confidentiality and probably not wanting family members to know the existence of a particular relationship that they have during a lifetime. That is actually very sensitive. And instead of making everything in one document, he or she may consider making partial wills to designate a particular property to a particular person, but actually that creates a lot of trouble as well, particularly in terms of the succession process, especially when the executor of the two wills are competing over who should be administering the estate or which extent of the administration that they are entitled to, things like that. So another way to do it would be to set up a family trust, which is completely confidential. Just settle that particular account or property into a family trust with the person named as the beneficiaries so that it will not form part of your estate upon your death. And the family members will not be aware of it. It's clean and clear.
Very good way to keep a secret then.
Oh, we know how to keep a secret, don't we?
So we actually just want to moving on now. You had mentioned earlier about the enduring power of attorney.
Yes.
So in general terms, what exactly is an enduring power of attorney?
Enduring power of attorney is a piece of legal document that allows you to appoint someone to look after your financial affairs when you lost mental capacity. The mean enduring means that it endures upon the loss of your mental capacity. Normal power of attorney ceases to have effect after you've lost mental capacity because the attorney can only look after your wealth as if the way that you look after it. The enduring power of attorney gives the attorney a power to look after your assets after you become, in a way, gaga, that is, incapacitated. And actually, we do see a lot of this kind of scenario happening when an overall longevity of a person is continuing to prolong. I mean, we are looking at a lot of elderlies who are totally physically capable, but then they cannot remember things, they cannot recognize people anymore. And it is the time when the family members may have to have access to their financial resources in order to look after them. And if he or she does not have the proper power to do that, it will only attract controversies by other family members who will challenge the decision. And actually, an enduring power of attorney could save those family members a lot of money because without that, they will have to make an application to court for a court order. We call a committee order. And in order to apply for a committee order, they need to have at least 2 certified medical practitioners on the list of the hospital authority to give a medical report confirming their loss of mental capacities, which, of course, they have to conduct a mental test and all this. And they also need to, in the application, put forward a certificate of family and property, which means that they have to set out all the family members and all the properties under the name in order to convince the court that they are the person who is suitable to look after the financial affairs for you. And that is actually a quite long process. It would normally take around 4 to 6 months, with due notice to the family members and most particularly the official solicitors. And the cost would be far more to preparing an enduring power of attorney. So it's actually cost-effective for anyone to make a enduring power of attorney. And it's actually not a very complicated process to have one made. All you have to do is to have an enduring power of attorney drafted in accordance with the Enduring Power of Attorney's Ordinance, Cap 501, have it properly written, witnessed to signature by a lawyer and a medical practitioners. And all can be done with a lawyer who is familiar with this process. And afterwards, you can make sure that it only takes effect after it's registered with the High Court of Hong Kong. So it's actually a very straightforward process that I do encourage everyone to have one, especially when they're coming to an age that they may run the risk of losing their mental capacity.
Okay, so yeah, that actually just answered my question I was going to ask, was who and when should get an enduring power of attorney then? So I think you've answered both of those just now.
Yes.
So basically everyone who does a will should probably also consider doing the enduring power of attorney as well.
Yes, because especially when you never know whether you will come across a scenario that you may be hospitalized, you become unconscious, but then you have to be looked after. And that person can have access to your financial wealth in order to look after you.
So we've talked about the enduring power of attorneys just now, about how you can have someone else look after your financial assets. But what about your actual health, your actual person, in the event that you do become mentally incapacitated?
And in that respect, Hong Kong is very behind compared to a lot of Western countries. We do not have a Funds Health Directive. We do not have living wills. In the UK, for example, there's lasting power of attorney appointing someone to look after your financial welfare. No, sorry, your welfare. General welfare, but then there's no lasting power of attorney in Hong Kong. And there is actually a Funds Health Directive, but it's not, strictly speaking, a legal document in the sense that it's not legislated under the Hong Kong law to make it a legal document. Yes, you can nevertheless make an advance health directive in a form prescribed by the hospital authority to make sure that the doctor who will be looking after you when something happened to you will or will not administer some sort of medical procedure on you, like intrusive medical procedure like surgery or open heart surgery, something like that. But then it's only very restricted to a particular type of medical treatment that you will or will not receive. You cannot empower someone to make a decision for you. And that is a very big difference, in particular when we're talking about people in relationship that is not recognized under the law. For example, cohabitee or people in same-sex relationship. A lot of time, if they come forward to the doctor and say, I don't want him to do that, I don't want her to do that, their wishes may not be recognized or respected by the doctors, as particular when there are arguments among other family members over what he should or he should not have. So to avoid argument, it's best to have something properly in place to make sure that your wishes are heard and respected.
So even though you mentioned earlier that Hong Kong law doesn't actually accommodate for these advanced health directives or for living wills, still a good idea to have one just because it does express what you wanted.
Yeah, make sure that there is something in place for your wishes to be heard and respected, because usually in that kind of situation, you cannot speak for yourself.
Yes, I would assume so if you've already mentally incapacitated or hospitalized. Okay, so let's move on now to the topic of probate and estate administration. If my family member, my beloved family member, has just passed away, what do I do? What is the first step that I need to start on this painful process?
Okay, the first thing that you have to look after is make sure that your family members will rest in peace. Have everything done in terms of funeral arrangement. Have the body properly buried with all the family members, doing it in a way exactly like how your family member would have wanted. Of course, it would be great if he or she can be very precise about what he or she wants. I still remember that we had elderly family members who told us exactly what he or she wanted. In the sense that I don't want to be cremated, for example, or I want to wear that in my coffin, effectively like this. Because there's actually a lot of elderly people who think about what they want after they passed away. But then, of course, usually it's like a verbal instructions or wishes. If a properly drafted document can actually set out all these, for example, I want white roses. I want a party instead of like a crying ceremonies or crying contest. Actually, it helps family members look after the post-mortem affairs.
So basically, you're saying that in our will, we can be very, very specific about how we want our funeral arrangements to be attended to, what color dress and jewelry and shoes I want to be wearing in the casket, open viewing, no open viewing, everything can be appointed in the will.
Down to the very bottom of what color of flowers you want for the funeral home. Yes, but usually that would be in the letter of wishes. We wouldn't put it in the will because it may become a big document. So we want to leave the intimate details to the family members only. And the second step, after all this is done, is to look at the probate process. The probate process very much depends on whether there's a will or not. So your family member should be looking for your will. But of course, if you put it in your drawer with your other personal effect, it is not the most secure way to do it, because if a will is destroyed, there's a presumption that it's revoked by you. So we would always advise our client to put it in our safe. And only keep a copy and let the family members know after they look through your personal effects that the origin of the will is with your lawyer. So it will be safely secured without any risk of anyone destroying it only for the reason that he or she doesn't like what you have done. And actually, this is a criminal offense itself, destroying a will. But then you don't want anyone to attempt to break the law. So this is the will part. If he or she can look for your will, then the next thing would be to look at what you have. You may have bank accounts, you may have real estate, you may have stock or shares, private vehicles, boats, etc. So usually what people would do is to go through your drawers and find as many bank statements as you have. But now it's becoming more and more difficult because of the
Because we're doing e-statements now,
Exactly.
which brings the next question. How do you do it if there's e-statements? You don't know what these bank accounts are and you can't log into their bank account or their email.
So the best way to do actually is to put the answer to the secure question in a safe place, probably together with your will. You don't put it in your drawers that anyone can look into. You put it together with your will, with your lawyers, so that it will be completely safely secured and sealed, that nobody can look at it. But then if it is necessary for your family members to have access to your, for example, email account, and go through the email to see what sort of bank statement or bank email that you would have, then it would be an easy way for them to find what you have when everything is suppressed, when papers suppressed.
Okay. You mentioned earlier that you do suggest that sometimes clients, they should store their will in a safe deposit box. Now, if it's in the safe deposit box and they've passed away, I can't access their safe deposit box, can I? So how do I access their will?
So if there's a safety deposit box, usually what you would do is go to a lawyer, ask them to make an appointment for you to have access to the deceased safe deposit box. The process would be your lawyer will be making an appointment for you with the bank with the presence of your Home Affairs Bureau, Home Affairs Department. And there will be an appointment that the officer at the Home Affairs Department will go to your safe deposit box, take an inventory list, and that list will be appended to the intended probate application. But of course, that also means that everything in your safe deposit box will be inventorized and become part of the public document. And if there's any will that they find in the safe deposit box, they will take it out. The only thing is that usually an appointment like that takes around 2 months before it can be assessed. So it is much more complicated process compared with keeping the will as, for example, your lawyer. That the family members can go to your lawyer and say, my family members have passed away, can I have the will? So the lawyer will be under the responsibility to make sure that you indeed passed away before they release the will to family members.
Okay, so I just have to make sure that my family members know who my lawyer is, who did my will.
Exactly. And usually,
one more thing to remember, though.
No, it's actually absolutely all right if you go to a lawyer who professionally drafts your will, because they must put down their contact details. And indeed, if they can find your will, what they can do is to ask the lawyer to post a notice at the Law Society weekly circular, and the law firm would go through their list every week to see whether they have any client prepared any will, that they will come forward and notify the family members. And that is another reason why it's advisable to have your will drafted by a professional lawyer.
Very good to know. Okay, so let's say I have found the will and I have identified, I think, all of the assets and liabilities of the deceased. What do I do next?
You cannot find the will of the deceased.
I found the will.
You found the will.
I found the will.
Okay, you found the will, and you go to a lawyer, and then you start instructing the lawyer to prepare the probate process for you with completing necessary document, which would be in the form of an affidavit. Of course, if you ask me, do I need to go to a lawyer to apply for probate? Probably not. You can do it yourself. The court would not discriminate you if you do it yourself. But then you have to go to the court a few times. You may not have all the necessary documents in place. And then you probably may get shouted at a few times. So it's easier to go to a lawyer and
let the lawyer get yelled at.
If they're good enough, they won't get out there because they know exactly what they should do to prepare probate process and prepare probate documents. And it will be much more straightforward, and all the legal fees can be deducted from the estate.
Oh, good. Very good to know. So if everything goes very smoothly and my lawyer is excellent, how long would the probate process take if I found the will?
If if there's a will, the probate process will usually take around 2 to 4 months.
That's not too bad.
Yeah, compared with the intestacy application, which would take much longer.
Intestacy being without the will.
Correct.
So what do I do if there's no will? I cannot find the will advertised and no one can find it anywhere.
Okay, if there's no will, then you have to prove 3 things. First of all, that the deceased passed away, your family member passed away. That is by the production of a death certificate. And secondly, there are assets in Hong Kong. That is what we've just gone through, the search of assets and liabilities with the setting out everything that you have under the deceased name. And the third thing is that you as an applicant is entitled to administer the estate. And that will require the proof of your relationship with the deceased. And under the Hong Kong law, the assumption that the deceased is a Hong Kong person, it is a list of priorities that the immediate family members are entitled to administer the estate. The first, spouse. Second, children. Third, parents. Fourth, siblings. So provided that they are entitled to administer, to inherit the estate under the intestacy rules. So in order to prove the relationship between the applicant and the deceased, they need to produce public document. And actually, when we're talking about death certificate, birth certificate, marriage certificate, these kind of public documents that prove the relationship, if they are Hong Kong issued, for example, death certificate, marriage certificate by the authority, all you take is certified true copies. Certified true copy, which is relatively straightforward. You pay a fee and then you get it immediately almost. But then if it's issued by foreign authorities, then it has to be authenticated. If necessary, it has to be apostilled, that is to show the authenticity of a document, or legalization to make sure that that document is valid and genuine, issued by a competent authority. And that can be a very complicated process because you have to go to the foreign document countries, go to the relevant authorities, find the right authorities, and then deal with the bureaucracy. That can give a lot of heartache and headache to the family members who need to procure these documents. So this is another reason why having a will is so important, simplify the probate process.
It gives them peace of mind, I suppose, in a way as well.
Exactly. And then we've just talked about Hong Kong related in relation to the person who died domiciled under the in Hong Kong. Hong Kong laws govern those who die domiciled in Hong Kong, and domicile is a common law concept that is quite complicated. We're not going to elaborate it today, but then if anyone was not domiciled in Hong Kong, then the probate process will be governed by the law of the place where he died domiciled. And that would be an extra complications. And that also requires competent lawyers to advise the applicant properly. And that also emphasizes the importance of having a will, which make all these issues go away.
Actually, that raises an important point then. Could I, in fact, in my will, state that I want it to be governed and interpreted in accordance with Hong Kong law?
Yes, you can. And you also can make a declaration that you're domiciled in Hong Kong.
Okay, so that kind of streamlines things a little bit then.
Absolutely.
Very good. Okay, let's move along then a little bit. So you've got your grant now. You finished the whole entire probate application, whether testate with the will or intestate without the will. And now you finally got that final document from the court that says you, the applicant, are allowed to deal and handle the estate. What do you do?
Okay, the next step would be to administer the estate with the grant finally issued, which is like, oh.
It's an achievement.
Exactly. The next one would be to administer the estate. First of all, usually we call it the low-hanging fruit would be to close the bank accounts. The closing of the bank accounts is relatively straightforward. All you have to do is to bring the will to the bank and fill in all the paperwork and direct the bank to transfer the proceeds to a designated bank account that you keep for the benefit of the beneficiaries. And in that respect, of course, you should separate the estate money from your own money with a fresh account in order to give a proper account to the beneficiaries. And bank account is relatively straightforward. But then if we are talking about other properties such as share certificates, you may have to liquidate it by depositing into a broker, doing the transfer and all this. And safe deposit, but of course you have to surrender it and getting all the valuable properties out and then distributing it to the beneficiaries. They may fight over, I should have this earring, I should have this necklace. Help them to resolve among themselves how to get whatever there is of sentimental value to them. And finally, in terms of real properties, they need to sign legal document in order to transfer the legal title from the deceased name to the beneficiaries. And if necessary, the beneficiaries may agree among themselves how to distribute the properties. For example, some of the beneficiaries may not want to inherit the properties. They will want to have cash instead. So either the other beneficiary can buy the share out, or the executor can simply sell the properties and distribute the proceeds. And in that respect, of course, Hong Kong is in a very unique situation which anyone who is already a homeowner, if they get another property, they have to pay an extra stamp duty. And a lot of people may be discouraged from inheriting a real property.
Okay, so I'm going to assume then that that step earlier where we identified all of the assets and liabilities of the deceased is for the purpose of distribution of the estate after you get your grant. What about the liabilities?
The liabilities is very important to first of all identify the liabilities, making necessary inquiries with anyone who may be your deceased creditor, such as the bank, credit card debt, personal loans. Make sure that after collecting the assets, you pay the debt first before you make the distribution. And afterwards, if you're not sure, what you should do is to make an application to court to limit the time that any creditors can come forward and claim against the estate for any liabilities that are allegedly due and owing to them by publishing a notice on the Gazette. And after a period of 60 days, you can safely distribute the rest of the estate to the beneficiaries.
Okay, so it doesn't take that much time at all then. Okay, so what if none of this goes smoothly and someone starts to argue? One of the beneficiaries is not happy with how the estate is being managed, or they're not happy with how some of the items are being distributed because there was no will that sets everything out. What can this unhappy person do?
I would say the first thing that the person aggrieved, the unhappy person should do is to go to a lawyer. Because every situation is different. The first question that usually we ask is whether there's a will. If there's a will, whether there's any reason to challenge the will. To challenge the will, there could be a lot of reason from the fact that the person who signed the will was not aware of the legal effect of the will, the contents, the legal effect, or they lack the mental capacity to sign the will at the time, or they're not properly explained about the legal consequences of the will. And this is particularly the case for vulnerable clients who are elderly or who may not be entirely sure about what they're doing. And another alternative would be whether there's any particular circumstances to render the will unfair in the sense that you do not believe that the person who made it was totally voluntary. We have come across so many circumstances when old people, when they become older, they need someone to look after them. And some of the family members may spend a lot of time with them, and then they gradually become convinced or reliant on them. And when they make a will, leaving everything to those people, and you're not a beneficiary, you usually may wonder whether that person have done something to make that person leave everything to them. All are very fact sensitive, and it requires an experienced lawyer to look into your situation in order to advise you properly over whether there's a valid claim. And before everything is in place, the first thing that probably your lawyer will advise you to do is to put in a caveat. A caveat is effectively a hurdle for the court not to issue any grant of probate or letter of administration without notice to you. And anyone who wants to apply for the grant will have to clear you off first by asking you either to withdraw the caveat or have it properly litigated. So, the first thing, irrespective of whether you have a claim or not, if you're not sure, your lawyer should put in a caveat for you immediately.
Okay, so as long as you just put in the caveat first to stop everything from proceeding, then that at least gives you some time to think then.
Exactly. Give you some time to think, get advice properly, conduct your investigation, either making inquiries with the lawyers who prepare the will for the deceased, or seeking proper medical records to ascertain the deceased mental status at the time when he or she executes the will.
So I guess earlier you mentioned about just the voluntariness of the deceased when they signed the will. I guess that also goes back again to the point why you need a lawyer to help you draw up the will, because the lawyer will probably help you get around this whole entire voluntariness issue, right?
Absolutely. And it's very important for a professionally trained lawyer to keep all the records in place properly. And in particular, to administer the proper questions to the client before they sign the will, in order to make sure that that person knows the legal effect of the document that they signed, and they understand they are doing it in all voluntariness.
Okay, so let's say I've established that there is something that's not right, whether it's the signatures in question or the person was not mentally capable at the time, or the issue of voluntariness. What would I do next?
The next thing would be to consider whether to challenge the will. If you're challenging the will, you can do it in two ways. Either you put in a positive case to say that the person who signed the will lacked the mental capacity or other reasons to say that the will should not be probated. Otherwise, you are just putting the burden on the executor named in the will to prove the will in stolen form. And you put forward evidence to show contrary, or we call it raise a suspicion to the court to investigate, so that it will be properly examined by the court before determining whether the will is valid or enforceable or not. So that would be for the will part.
So what if, say, I didn't raise any objections before the grant was applied for, or the letters of administration, but subsequently, when the estate was being dealt with, I become upset with how it is being handled. What are my reliefs at that point?
Okay, so the first thing that you have to look into is whether you are a beneficiary and you're aggrieved by the way that the administrator or executor handling the estate. For example, lack of proper account, failing to answer questions, taking necessary steps to recover the estate from the any third party. Go to a lawyer, discuss your situation, and see whether you are entitled to pass over the administrator, remove the administrator, and get the result that you deserved. Otherwise, if you are actually not entitled to the estate, but then you're aggrieved by it, you may want to seek professional advice as well as to whether you can make a claim against the estate, as said earlier, in particular if you have been financially dependent on the deceased. And that is actually a separate claim, but we can talk about it another time.
Okay, and just one more thing about a person who is not actually entitled under the will is, what if, say, I'm a creditor of the deceased, credit card company or something like that, and I haven't been paid out of the estate in advance as one of the liabilities?
Okay, it's actually very common for financial institutions if any of the clients passed away and owing monies to them to put in a caveat so that the person who is going to administer the estate will enter a personal undertaking with the creditors to make sure that he or she will personally be liable to pay, to settle the debt after they've collected the estate.
Okay, so are there any other common problems that may be encountered during the management of an estate?
Lack of account is, of course, one of the major reasons. But another common problem that a beneficiary may face in terms of estate administration is the person who administers the estate taking advantage of their position. For example, he or she is living in the family home and they're not paying the rent. And they should indeed be accounting for their occupation of a property that should be distributed among the beneficiaries. And that is why we emphasize the importance of having someone who is reliable to administer the estate. And in that respect, a lot of people do not aware that putting this burden on the family members may put them in an embarrassing situation, giving rise to sibling rivalries, for example. And that is why a lot of time it's very important to make sure that the family members will have an understanding among themselves in relation to what they should do, what they're entitled to, what they're not supposed to do. And managing the family members become a process that a person administering the estate should have in giving account to them for their benefits. And in that respect, if there's any dispute among the family members over how to deal with an estate, one of the many ways to resolve such disputes is by way of mediation. And mediation is actually an effective way to introduce a professional and impartial third person to help the beneficiaries resolving the differences by trying to present different perspectives and deriving different solutions for them to consider. Bringing a third party to look at everything objectively can put people into perspective and attempt to resolve it with a little bit of compromise in exchange for a lot more benefits, such as to avoid a protracted legal battle. And of course, another way to avoid it is to have someone professional to administer who care about their own reputation and their professionalism more than anything else. And he or she usually is not a beneficiary. So they have no reason to abuse their power. They will only administer the estate properly in exchange for proper remuneration. And this is why the benefit of having a professional administrator is that they know what they're doing and they will not do what they're not supposed to do for their own benefit.
Okay. So who could be a professional administrator then?
That person can be an accountant, lawyers, or anyone who has the professional capacity or experience to administer the estate, who have the experience before.
Okay, and that wraps up our podcast on private client estates and trust. So big thank you to all of our listeners who are joining on this podcast. And also thank you to Alfred, our private client lawyer, for assisting us with all this information.
Thank you, Margaret. And actually, it's a very good opportunity for me to share my experience as a private client lawyer. I hope that after hearing this podcast, a lot of people will realize the importance of having a proper lawyer to advise them on estate planning related issues, and hope that there will be less dispute among family members and the wealth can carry on through generations.
Be sure to catch our other episodes of the Hip Talks podcast by checking the insights section of our website at www.hugolandip.com. And please send us your comments by writing to our email address hello@hugolandip.com. Also, please feel free to share this episode of the Hip Talks podcast with your friends, family, and associates. For the hearing impaired, you can find the notes and the transcript of this episode on our website. This podcast is for informational purposes only. Its contents do not constitute legal or professional advice.